I would like to welcome somebody from Wanjiku and Kanyere Advocates. So, you see, I have just done a session about how I made income in 2024, and I gave you a very good list. So, it's very, very important, number one, to figure out how to make money. You have to figure out how to make more money as time goes by. The second thing usually we need to figure out is how to protect that money. So for example, you need, as basic as you need health insurance. Because in Kenya, we're usually told you are one critical illness away from getting such a big medical bill that you slide back into poverty. So in as much as you're concentrating on this is how I want to make money, remember to protect your money. Get life insurance, get critical illness insurance, get medical insurance, so that if anything ever happened to you, you don't have to start from scratch again, because that is very critical. Now, after you've built your income, after you've protected your income, it is very important to ask yourself, if I passed on today, or even if I woke up and I'm 65 years old, how would I like my property to be distributed? Estate planning. How would I like my estate to be distributed? So for example, do you have an estate plan? Do you have a trust? Do you have a will? If you passed on today, who would get the money that is in your money market fund? Who would get the bonds? That's a very critical question. And so that's why I'm welcoming Wanjiku, Wamuyu, from Wanjiku and Kanyere. I keep calling her Wanjiku and she's the Wanjiku. Wamuyu from Wanjiku and Kanyere Advocates to talk to us about estate planning. It's a very short session, but I promise you're going to get a lot of value.
Good.
Welcome, her with a clap.
Thank you so much. Good morning.
Morning.
Good morning again. So thank you, Agatha, for organizing this beautiful event. It has been truly beautiful. And personally, I have learned a lot. And I'm sure a lot of people here, the number of incomes they'll have this year, or the sources of income they'll have this year, won't be comparable to last year. I'm almost positive about that. So as she has said, my name is Wamuyu Kanyere. I am an advocate of the High Court of Kenya. I run a practice called Wanjiku and Kanyere Advocates together with my colleague Wanjiku. Wanjiku, please wave to the people. Thank you, Wanjiku. And so we have a very short presentation to make, actually a maximum of 15 minutes, hopefully. And basically what we are talking about is wealth management and succession planning. As Agatha has mentioned, I'm sure all of you are here because you're keen on making wealth. And generational wealth, if I may say. And in your journey of wealth creation, definitely you are here because you're learning how to make money, or you're learning how to increase your sources of making money. And after that, obviously, I know a lot of you also know about how to save that money or spare that money. And you also know how you can invest that money and even diversify that money so that it can grow. And also questions have come up about insurance. Insurance comes to help with insurance now comes to help with wealth protection. That's whereby now you keep an emergency fund, or you have a medical insurance or a critical illness cover. And these are to just shield you in the event that a scenario were to happen and it threatens your entire investments. Usually in Kenya we say many people are one serious illness away from poverty. And as sad as that sounds, it's actually the truth. So wealth protection is the other stage of wealth protection that you have to think about. But lastly, and this is something that most people don't talk about, and that is estate planning. And estate planning is, we can categorize it into preservation of wealth and succession planning. And I'm talking about preservation of wealth because estate planning is not just about preparing for death. There are other things, there are other tools that are available to us which we can utilize and preserve our wealth even as we are growing it. First of all, the reason why we are having this discussion, for those people who may have lost a parent or know someone who has lost a parent, you may know or you may have heard about what we call succession messes. The people who've done succession will tell you it's one of the most lengthy, cumbersome, draining, and expensive processes. And the reason is, the moment you lose a loved one, like a parent, the first thing you first has to grieve. But even before you can process it, you also quickly have to snap back and also deal with the issues of succession. And the first step of succession will be coming up with an inventory of what that person left behind. And this is usually where the rubber hits the road, because many people in our culture, you will agree with me that many people make their investments secretly. And even when it's not outright secret, they're just not so keen on disclosing. We usually use this term, no kogeria money. Those people who use that term, it's the people who are really wealthy, but when you look at them, they are always like, no kogeria money. And that is the kind of culture we come from, where people don't disclose. So you can lose a parent, and when you're trying to come with an inventory of what that parent left behind, all you have is bits and pieces of information here and there, documents here and there, which it's very difficult to put together to come up with a comprehensive list of what that person owns. And if you want to understand how serious that situation is, I'll show you some statistics. These are the statistics. You may have heard about the Unclaimed Financial Assets Authority. This is an authority that was set up about 10 years ago, actually less than 10 years ago, and it's mandated with the function of holding unclaimed assets. So this is money that has been held by banks or other investment companies, which the owners died and there's nobody who laid a claim to that money. So these are the numbers, these are the statistics that they have, that in that period of operation, they have handled 36.1 billion in cash assets, basically in cash, right? And actually, if you read further in their statistics, from that 36.1, only about 2 billion has been claimed. So you can imagine that they are still holding on to a whole 34 billion belonging to people, and those people don't know that there's money they're entitled to that is lying at the unclaimed financial assets accounts. Again, they're also holding about 1.9 billion units in shares. These are now the stocks. They're holding 3,737 safe deposit boxes, and they're also holding 9.9 million unit trusts. So these are the money market funds, the fixed funds, the balanced funds, those ones, the unit trusts. So these statistics show you exactly how dire that situation gets. When you do not have this information and there's nowhere, because that person didn't make a plan, they didn't write a will, they didn't set up a trust, they didn't also talk to anyone about it, so nobody knows where this money is. And this is not taking into consideration the pieces of land. I don't know if you guys have heard about people who say they haven't paid rent for years. Yeah, because we have scenarios where rental properties are left, the owner dies, their family didn't know they owned that property. So 1 month, nobody comes to collect rent. The next month, nobody comes to collect rent. And of course, those people are happy to stay there rent-free. So you can imagine the pieces of land that are lying around because, the owners died and their family didn't know about it. We also have titles. I'm aware of titles that are held in bank archives because somebody took a secured loan. They deposited their title with the bank. They died. Nobody knew that there was a title lying in a bank somewhere. And so what happens to that property? A property that would have benefited, their children, their children's children, just ends up not benefiting anyone. So this is how dire the situation gets when you're trying to do succession without an estate plan in place. Coming back to the other issues with succession, it's the probate process. As I've said, the probate process is usually very difficult. It's long. A normal succession case will take between 3 to 5 years. And the complex ones, we have like the Mbio Koinange case, it took about 40 years. So that tells you how problematic it is. Another reason why it's important to do estate planning is tax planning. All of us like to save on taxes, I'm sure. So we have tools and we are going to discuss them. We have tools of estate planning that can also help you manage your taxes as you do your investments, and we are going to discuss them. The other thing is privacy. If you're able to plan your estate very well, and in this case use a tool like a family trust, it can guarantee you privacy, such that you don't have to have your dirty linen aired in public. For those of you who followed the Gachagua succession case, you may have heard about the late brother's assets or estate being discussed in parliament and not in a very good light. So estate planning guarantees you things like privacy, because if you set up a family trust, that trust doesn't have to go through probate. That ensures that you're able to, keep your affairs together and within the family. The other thing is family disputes. This one is, you may have, experienced cases where a family is left and then the siblings maybe start fighting over what has been left. Number 6 talks about ensuring long-term provision for loved ones and vulnerable individuals. Now, what happens with intestate succession, and now that is succession where the person who's passed on did not plan their estate in any way. One of the consequences of that is that depending on the age where the people have been left behind are, for instance, imagine a 19-year-old inheriting an estate worth, say, 20 million. Would that person know what to do with that money? Even assuming it's in cash assets, will that person know how to do with that money? Most likely the answer is no. Because one, this person is very young. This person is very impressionable. This person is very easy to manipulate. And they also don't have financial education. The amount of education we are here to seek, they probably don't know that. They don't know there's a place they can put their money and their money grows. So they're very likely to, finish it within a couple of months, sometimes years, and it doesn't help them in the long run. That's the same thing that happens with also vulnerable individuals. If someone leaves behind a child, say, who has autism, or who has cerebral palsy, or any other disability that puts them at a disadvantage when it comes to getting an income, they are not able to be protected in intestate families, because whatever it is that you leave them behind, you leave for them. If there's no plan on how that is going to be reinvested and reinvested, it's likely not to benefit them in the long run. Then we also have the issue of family businesses. We have people who, during their lifetime, they create very thriving businesses. And, especially people from his community are very, we know them for creating very thriving family businesses and putting in place structures that ensure that those businesses continue even after, generation after generation. But us as a community, we don't really, we don't have that culture. And so we can borrow a leaf from that, and we're going to discuss that further. So still on the problems of, on the challenges of probate, we talked about how to come up with an inventory is always a challenge. The bureaucracy process, getting the succession papers, from the death certificate to the chief's letter, for those who've done succession, these are some of the documents you have to put together. You have to get searches for your titles, you have to get statements, you have to advertise your petition in the Kenya Gazette, and these are usually really cumbersome processes. In the end, you end up with a very lengthy process, cumbersome, costly, because all this time you're paying legal fees, you're paying disbursements, you're paying gazettement fees and all that. Distribution battles. Now this comes where you've been left with an estate. There's a rental property in Muthaiga, and there's a plot at Kamakis. Of course, nobody wants to take the plot at Kamakis. Everybody would want to take the rental unit at Muthaiga. So that usually creates challenges, and that's why most succession cases take a long time, because you have to, keep trying to talk. You are sent to the chief to try and mediate. The chief is not able to mediate. You get a private mediator. You try to mediate. You're not able to, you're not able to agree. So you keep moving back and forth. We have successions that have taken so long that some of the beneficiaries end up dying even before they get a taste of what it is that, they should have gotten. And that is usually also made worse where there are complex family dynamics. For instance, in the case of multiple spouses, or even when there are no multiple spouses, we know sometimes also we get this issue of cohabitation. Someone was living with a man, and they believed that they were married. Then on the day of the burial, they appear at the funeral, and they say they want to be recognized as a wife. But mostly, usually, it's for inheritance purposes, and that really creates problems. Also, where there are children that are born out of wedlock, and they were probably secret children, there's always problem with that. So it prolongs succession in a very big way. The other thing is lack of equity in distribution. When there's no estate plan, and nobody knows what the owner of this estate would have wanted, usually the court will say everything gets inherited equally. So if it's 4 children, there's an estate and there are 4 children, you'll be told you get an equal share. But what the law does not take into consideration is that the food children, they have different needs. Say one of them is educated and they have a good job, they have a good income, they're able to sustain themselves. So for them to be given the same portion as someone who is still in school and needs school fees and needs a lot of taking care of before they can set themselves up, it's usually challenging. So when you make an estate plan, you're able to provide for those two people in a different way and in a way that suits their needs. But when you do not do it, you leave it for the court to say, you inherit equally, kila mtu ajipange. And so, and this is now we are coming to where whatever wealth you have built over the years, it ends up depreciating. Why does it depreciate? One, there's the unaccounted for assets. Number two, there's the succession cost. Number three, sometimes you find that assets get subdivided into very small portions that are not economically viable. So for instance, you'll find a very small piece, a land being divided into very small portions that it cannot really be of economic value. And then also there's the lack of structure for family businesses. You find there was a very thriving family business, but now because there's no structure, there's no foundation for how the business should continue. You see some people want to sell their shares, other people don't trust each other to decide who will take leadership for the business. So usually most family businesses become unsustainable. And so these are some of the consequences that lead to depreciation of the wealth. And other consequences are what we've talked about: no equity in distribution, the minors and the vulnerable individuals are left without long-term provision, and there was also the danger of wastage from spendthrift individuals or even persons who are battling drug addiction and things like that. So what is the solution? The law offers us certain tools that people can use to manage their estate, and we're going to discuss them very quickly because I don't think I have much time. But basically, these are the succession planning tools that we have. We have power of attorney, you may have heard about it. We have guardianship, we have beneficiary nomination, we have joint ownership, we have gift inter vivos, we have wills, and then we have family trusts. Now, to take you through them very quickly. With power of attorney, you may have heard about it. Basically, this is where, for instance, I'm traveling for maybe medical care in another country and I'll be there for about 3 months. I won't be able to do things. And Wanjiku is my partner and I've left a business. So I can appoint her, I can give her my power of attorney so that whatever it is that needs to be done during the time when I'm away, she's able to do it and the business continues running. So you use power of attorney for different reasons or different scenarios of incapacity, either medical, geographical, whichever. We have guardianship. Guardianship comes in where someone has been declared to be of unsound mind. So people of unsound mind are not allowed to conduct legal businesses. So when you know that somebody close to you has been declared to be of unsound mind, what you do is you apply to court to get something called powers of guardianship. And the powers of guardianship will enable you to run their affairs as if they were able to. We have beneficiary nomination. This usually will apply for pension benefits, it will apply for insurance covers and things like WIBA benefits. And these ones, usually we call them non-probate assets because whoever it is that you nominate to be the beneficiary is the ultimate beneficiary. So even if you were to make a will and give that property or give those benefits to somebody else, the will fail. Now, the important thing to note when it comes to beneficiary nomination, many people don't revise these forms. So maybe you sign up for an insurance cover when you're very young, maybe in your early 20s, continue funding it. Then along the way, say you get married and you do not revise the forms of nomination. So many times it becomes a challenge when people's circumstances change in life. Maybe they get married, maybe they get divorced, yet they do not revise these forms of nomination. It usually creates problems at the end. So it's very important that you be keen to revise those forms as often as need to be. Joint ownership is where you own a property jointly with someone with the intention that when one person dies, their share is inherited by the other person or the surviving person. Absolutely. It's a form of estate planning because you can decide maybe you have a matrimonial home. So instead of living to create problems, you get that property registered in your joint names, and then you are sure if anything were to happen to the husband, then the wife will get the property absolutely, and vice versa. So then you are sure that nobody else will come and, try to lay a claim or cause difficulties. And the good thing with joint ownership is that when you are registered jointly, you don't even have to go to court to enforce that right. It's usually automatic. We have gift inter vivos. This is where you gift someone during your lifetime. So you decide, I already know who I want to have this property, so you try to transfer it. But the challenge comes with the tax implications for that. So it's important to discuss with a lawyer so that they can advise you on the best way of doing it, which won't be very tax intensive. Then we have wills. I won't discuss wills in details because those of you who follow the Well Tribe, we have done some 2 videos about wills, very comprehensive. You can check them out. The thing that I want to discuss very quickly is trust. And a lot of you have been asking about these trusts. So basically, family trusts are a tool of wealth preservation during one's lifetime, but they also come in for succession planning. And it's the most superior tools amongst all these estate planning tools. And it's provided for under the law called the Trustees Perpetual Succession Act. And this act was passed in 2021. And the reason why the discussion about family trust was not very aggressive as it is now is because before 2021, the law on family trust was not very streamlined. There was a lot of gaps here and there. So what this law did was to streamline the process of registration and made it easier. The thing you have to notice is that a family trust is an untrading entity, so you cannot be allowed to trade with it, although you can incorporate a limited liability company that trades, and then you have the shares of that company be owned by the trust. A trust can either be revocable or irrevocable. We recommend that you set up a revocable trust so that, if you change your mind along the way or you want to make any changes, you are able to do that. But the other thing is that a family trust will benefit you with tax incentives. For instance, stamp duty. If you buy a property in the name of a family trust, you are usually exempt from stamp duty. And those of you who bought property and paid stamp duty, you know how hefty that fee is, because it's usually between 2% when the land is in municipal areas, in rural, in the interiors, and then as you come to town, the stamp duty is 4%, which is quite hefty. Because when you think about buying a property that is worth, say, 10 million, a whole 400,000 goes to stamp duty. So incorporating a family trust saves you such kind of taxes. It will also save you from capital gains tax when you are disposing of property, and you'll earn certain income tax exemptions. For instance, when a trust is making out a payment to a beneficiary, and we are going to look at the structure of a trust so that you understand how a beneficiary comes in. When a trust is making a payout to a beneficiary, for as long as that payout is less than 10 million in a year, or it's for educational or medical purposes, that income is usually tax-free. So the beneficiary can declare the income, yes, but they are not obligated to pay any income tax on that income. So this is a basic structure of a trust. So a trust is basically the person making the trust, who is called the settlor, appointing someone called a trustee to hold their assets or their wealth in trust for the beneficiaries. So for instance, just to make it a bit more practical, it's me deciding, say I have a child, for instance, say I have a child who is 9 years old, right? And I don't know what could happen, and I have accumulated some amount of wealth. So I decide, if anything were to happen, let me set up a family trust. Let me appoint Olive to be the trustee in my family trust. Then I move my assets into the trust, and I have Olive hold it in trust for my daughter, who is called Ashley. So then I'll be the client here. Olive will be the trustee there. This will be the trust whereby we'll move all the assets into the trust. And if I have any businesses going on, because the family trust cannot trade, I'll have my companies doing the business, but all the shares in the company will be owned by the trust, and then I'll have my beneficiaries there as Ashley. How will this trust now come in to benefit me? For instance, and now let me discuss the advantages of the family trust. One, all the assets I have put in the name of my trust, they are protected from creditors. So if, for instance, I were to get myself in a situation where I have legal battles, or I have a business deal gone wrong and now I have cases in court, or I signed a personal guarantee for someone, for a facility with a bank, and now they have defaulted and the bank is coming for my assets. The bank can come after whatever assets are in my own name, but whatever it is that is in my family trust, it is separate from my individual assets. So the bank cannot touch that, or any other creditor that takes me to court and gets a judgment in my favor, they cannot come after assets in my family trust. So that is how a family trust comes in for wealth preservation. And remember, when I have set up my family trust, I am alive. So I am getting these benefits when I am alive, right? So let's keep the avoiding probate so that we discuss the ones that will benefit me even during my lifetime. The tax exemptions. If I buy a property and put it in the name of my trust, I'm exempted from the taxes. So the process becomes very cheap for me. There's also flexibility and specific needs. For instance, I can decide my daughter Ashley, because I don't know when, anything could happen and I die, I don't want to leave her vulnerable. So I'll say in my trust, you Olive, if anything happens to me, whatever wealth it is that I have left behind, say I had a net worth of, say, 30 million at the time I'm dying, right? So this is in money market funds, this is in infrastructure bonds, this is in shares. I'll tell Olive in my trust, you keep reinvesting this money, and out of the income that is coming from this money, ensure that Ashley's school fees is always paid. Ensure Ashley always has a valid medical cover at any given point. And depending on the circumstances, maybe I can also instruct that she gets a monthly stipend until she's maybe at the age of 25, right? And this is now where you talk about the trust fund babies, because basically the trust will act as her trust fund. So whatever wealth, the 25 million or the 30 million that I've left, instead of giving it to Ashley and maybe she's at a young age and she doesn't know what to do with that, I can ensure that someone who is in a more experienced position is able to manage that money on behalf of Ashley, and Ashley is able to benefit from that wealth for a very long period of time. So I can say when she turns 25, give her half of that money, so that she can set herself up. If she wants a business, she'll use that as capital and all that. Then maybe if she turns 30, hand over now all the trust assets to Ashley, because now I assume by the time she's 30, she's grown, she's mature, she will know what to do, right? So that is how now the trust fund babies come in. So that's where now I'm talking about flexibility and specific needs. So you can address the specific needs of your children. So if you have a child with some sort of disability, and this person won't be able to compete, won't be able to be competitive in the job market like everybody else, you make a plan for them where they can be provided for even 30 years, 40 years, 50 years, depending on, the value of your estate. The other thing that a trust can do is to set a foundation for continuation of family businesses. And actually, one of the people that have been able to use this tool is Jenga Karume. If you look at the Jenga Karume case, is that he left a net worth of 40 billion at the time he died. And what he did was to set up structures to ensure that, one, his businesses continue to run, and the beneficiaries, or rather his dependents, continue to be provided for. And that trust has worked very well up to now. At some point, there were issues with the trustees, and they were taken to court, and some of the trustees that were not observing the trust deed were removed, and the court appointed a new set of trustees, but the trust continued to operate. The good thing with the law right now, when you appoint a trust, of course, when you're appointing a trustee, you definitely appoint someone who is mature, somebody who is trustworthy, and someone who will take the best interest, will have the best interest of your beneficiaries. Now, in the event that you don't have an individual who can do that, we have provision for corporate trustees. This is where you approach a corporate trustee and you appoint them to be the trustees for your estate. And what this does is to bring in professionalism. And we have corporates in this country who offer that service. For instance, ICEA. they offer that service. The other thing that the trust law provides is you can appoint an enforcer. So for instance, I can appoint Olive to be my trustee, but at the same time appoint my brother over there to be the enforcer. So what he will do will be to oversee Olive. So if Olive at any point becomes, maybe greedy and tries to do something that puts Ashley at a disadvantage, my brother as the enforcer is able to come in and rectify that situation, or take Olive to court so that that situation is rectified. Either she is removed as the trustee, or she's made to remedy whatever it is that she's been doing. The other thing is that once you have a family trust in place, if the moment you die, your family doesn't have to go through the probate process. So you don't need to go to court. You don't need to do the distribution. The trust will stay what the wishes of the settlor were, and that is what will be observed. So again, you'll have privacy because nobody needs to know what is happening within your family situation. Yeah, I think I have covered all of it. I don't know if I have exceeded my time, but thank you so much for listening to me. If you have any questions, or you want to know more about this family trust or even wills, because sometimes you can decide to go with a simpler option like wills, but it's better than nothing. So you can reach us on that email address or on those phone numbers, and we'll be happy to help you. Thank you very much for listening to me, and do have a lovely day.